The big one is, and this is happening right as we speak. There's a case that is probably going up this fall to the Minnesota Supreme Court called the Tatro case, Tatro, and that's a First Amendment case involving online speech by students on a Facebook page, and what's important to us about that is it's the first case that we know of that's gotten as far as an appeals court. This got to the Minnesota Court of Appeals, where a student was disciplined for speech purely on her personal Facebook page that had to do somewhat with school matters, but was not in any way directed at a school audience or intended to cause a disruptive impact on school. But because some people reacted negatively to it at school, the school decided that was good enough to punish the student, and they disciplined her, basically ran her out of this professional program that she was in. We have seen cases like that bubbling up at the high school level before, but this is the first one we know of where, based on this substantial disruption test under the First Amendment, that a college has punished a student for purely off-campus social networking speech based on its, the way people reacted to it on campus. So now that's not a journalism issue exactly, but it's certainly an issue. If I were a college student blogger, right? If I was running a WordPress site, if I was, doing any kind of political commentary or something like that on an off-campus website, I'd be watching that very closely because we do need to draw some better boundaries where schools don't feel like they're the 24/7 speech police. So that's the big one involving college students' First Amendment rights that we're following right now. And that, we probably won't see a decision in that until, I'm thinking, 2012, and that's in the Minnesota Supreme Court. It's in the state level court, but it's construing the First Amendment, so it won't be binding in any other jurisdiction, but it will certainly, I think, be one that a lot of people look to for guidance, just because there aren't that many. The fact is, the law of social networking is 5 years old at best, so we don't really have a whole lot of other guidance to go on. Yeah, I think the really big one that all of us in the media are looking at is the bundle of intellectual property and copyright issues that involve republishing part or all of other people's content. I mean, that's really quicksand right now. For a long time, it was kind of, a long time in internet years. For a long time in internet years, it was kind of accepted that if all I did on my website was post a couple of paragraphs of your story with a link to what you did, and I did no more than that I was making a fair use of your content. I wasn't violating copyright because I excerpted and linked, and I was still, at the end of the day, driving the traffic to your site. I'm not sure that we're 100% secure that that's always going to be right anymore. There was an old Supreme Court case back in the day when the news was being put out by wire services on news tickers, and it was called the hot news case. And what the Supreme Court said in that case was it was possible for a competing wire service to violate copyright or violate the predecessor of copyright, to violate copyright by stealing your hot news, basically. That if they took your scoop and republished it as their own, they could still be violating copyright even if they added a little bit of their own creativity to it. That scoop, at least for some period of time, was yours, and they couldn't just go republish it and resell it under their own name. And that hot news doctrine was dormant for a really long time, but some attorneys are trying to revive that now so that they can protect their online scoops from aggregator sites whose whole business model is just to republish entire chunks of other people's content. So yeah, that's one that the courts are still figuring out, basically how much of somebody else's material can you safely republish before you've crossed the line into copyright infringement? I still think that for purposes of the student media, if you want to put a paragraph, a sentence that says, kind of top national news headlines, and you summarize something that you saw on the front of the Wall Street Journal or the front of the New York Times, and you link directly back to them, I think that's awfully close to a fair use, and I have a hard time seeing how that would constitute copyright infringement. But you do want to reword it into your own words. You don't want to just cut and paste the first 3 paragraphs of the New York Times story. That's getting too close to the edge.